The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, counsel. I don't see counsel, but I did see Mr. Shanmugam. So if you're ready, you may proceed.
Thank you, Chief Judge Gregory. Canon Shanmugam of Paul Weiss for the appellants. May it please the court. In remanding this case, the Supreme Court directed this court to consider all of the other potential grounds for federal jurisdiction that would support removal. To begin with, federal jurisdiction exists because Baltimore's claims are governed by federal common law. However Baltimore frames its claims, it is seeking to impose damages for injuries allegedly caused.
What common law what federal common law is there in light of the passage of the Clean Air Act? What common law is out there?
Judge Floyd, there are two separate questions before the court, and really only one of them is properly before the court here. The first is the question of what is the appropriate source of law? Is that federal law or state law? And then the second question is the substance of the law. On the first question, the source of law, we believe that the body of law on which we rely in the briefing, the long body of Supreme Court case law applying federal common law to claims involving interstate pollution, applies here. The second question is the question of displacement, and that's a merits question, as the Supreme Court's decision in Standard Oil makes clear. And I would refer the court to the First Circuit's decision in Swiss American, which I think draws out this distinction at some length. And that is the question of whether or not there is a valid cause of action. And on that question, it'll be no surprise to you, Judge Floyd, that our position is that the Clean Air Act, in fact, does displace any federal common law, such that there is no valid federal cause of action. But that question is not before the court. The only question before the court is the question of the source of law, and our submission is that federal common law in this area supplies the exclusive source of law for plaintiffs' claims.
The Clean Air Act or Clean Water Act displaced common law, you're still arguing that the source of law is common law?
Yes, that is correct. And again, that is because there is the threshold. That sort of
seems a circular argument that, at least for me, defies logic.
Well, I don't think it's a circular argument, Judge Thacker, because the Supreme Court has directed that it really is a two-step inquiry. And indeed, I think that when you look at cases like the Supreme Court's decision in AEP, the Second Circuit's decision in City of New York, the Ninth Circuit's decision in Kivalina, although some of those cases began in federal court, I think they lay this out. Indeed, if you take a look at the Second Circuit's decision in City of New York, again, a case that began in federal court, the court first assessed the question of whether or not this is an area in which federal common law applies before proceeding to the question of displacement by the Clean Air Act.
Which then it said the Clean Air Act did displace common law. So are you saying we're just not to that point yet? And when we get to that point, you'll lose then, but you don't lose now?
The plaintiff will lose then in our view, but that will be a merits question that would presumably be resolved on a motion to dismiss once the question of the appropriate forum is resolved. And on that sort of threshold question, there's sort of two components of what we think that this court needs to address today. The first is the question of whether or not federal common law, in fact, applies in this area. And as I was noting a minute ago, our submission is that it really follows a fortiori from the body of case law applying federal common law to claims of interstate pollution, because these claims go further than mere claims of interstate pollution. They have an interstate and indeed an international component because of the pervasive role of the federal government in regulating global climate change. The second question before the court today, which is really the issue that my friend Mr. Scher raises in his briefs, is whether if federal common law applies, removal is appropriate. And on that question, we rely primarily on this court's decisions in Caudill and North Carolina, which stand for the proposition that where federal common law supplies the rule of decision for a plaintiff's claims, those claims necessarily arise under federal law, and removal is thus appropriate. And Baltimore, in our view, can't plead around the body of case law applying federal common law to similar claims simply by labeling its claims as state law claims. Now, I think Mr. Scher's primary submission and Baltimore's primary submission here is that the only possible bases for removal of claims pleaded under state law are where the claims raise a substantial federal issue or are completely preempted by a federal statute. But not only is that proposition belied, not just by this court's decisions in Cottle in North Carolina, but by the decisions of other circuits. We cite the Sam L. Majors decision from the Fifth Circuit, among others. But it really doesn't make any sense because the upshot of such a rule would be that a plaintiff would be able to avoid the application of federal common law simply by asserting that its claims arose under state law. And again, in our view, the relevance of federal common law here is not that it merely supplies a defense. It supplies the exclusive source of law, the rules of decision that would govern the plaintiff's claims. And again, Judge Thacker, that leaves us on.
Isn't your argument equally as broad? As I understand your argument, it almost doesn't matter how plaintiffs frame their complaints if in your view it sweeps so broadly that it would touch, that it involves climate change or global emissions, it would always be federal jurisdiction, no matter what the claims are actually in the complaint.
I think in our view, the causes of action don't matter as long as the plaintiff's theory rests centrally on the production and sale of fossil fuels and the use of fossil fuels worldwide. We think that's true with regard to all of plaintiffs' causes of action here, but it certainly is true with regard to claims like the nuisance and trespass claims, which are exactly the same type of claims, Judge Thacker, that were at issue in the Second Circuit.
So that puts the defendant in charge of what plaintiffs' claims really are, and does sweep as broadly as it sounds to me like you're arguing it sweeps. Everything would be federal no matter what the plaintiff's claims are.
Not at all, Judge Thacker. And while Baltimore suggests that we're somehow running roughshod over the principle that a plaintiff is the master of its complaint, let me explain why that's not true. I think this is very analogous to a garden variety choice of law question. Let's say that a plaintiff brought a claim. I live in the Commonwealth of Virginia, and let's say that there was a car accident, and the plaintiff nevertheless brought a claim saying that Maryland law applies. I think what a court would do under those circumstances, assuming, as I think would be true, that choice of law principles would say that the law of the Commonwealth of Virginia applies, is that the plaintiff would, that the court would simply say, we're going to apply Virginia law to these claims. What we're arguing here is analogous to that. And this isn't a pure choice of law question. The question of whether or not federal common law applies is governed by a discrete body of case law set out by the Supreme Court. But what we're basically saying is that where the exclusive source of law, again, the rules of decision that govern the merits of the plaintiff's claims are supplied by federal law, the claims necessarily arise under federal law for purposes of 1331. And I would
Well,
point
Mr.
the court.
Shanmugam, the Supreme Court asked us to consider all the grounds of removal, and of course you've talked extensively about the federal common law. Well, what other grounds for removal would you hang your hat on?
So we certainly continue to rely on all of the other grounds that we advanced in the initial briefing. But as you'll be aware, Judge Floyd, in the supplemental briefing, we focus on two grounds that we think provide the straightest path for this court to hold that federal law applies here. I've talked already about federal common law, and I think the reason why I started with federal common law is that we now have
clear
this.
You're not abandoning your Grable and preemption, all those other arguments, even though you didn't address them in your supplemental briefs?
We're not abandoning them, Judge Thacker, because we're content, particularly given the limitations on space in the supplemental briefs. We're really content to rest on our original briefing, and I'm happy to answer any questions about them. But I think the reason why we are relying primarily on federal common law is that we now in 2022, and this case has obviously been around for a little while, we now have a meaningful body of case law, not just talking about federal common law in the context of interstate pollution, but talking about it in the context of global climate change specifically. And if I could point the court to one decision today, it would be the Second Circuit's decision in the City of New York case, which I think sets out with regard to a complaint that is really difficult to distinguish from the complaint at issue here. Why it is that it follows from this
City
earlier.
of New York was not a removal case, was it?
Well, that is correct. And the one respect in which we would slightly disagree with the City of New York decision is the extent to which the City of New York suggested, well, the analysis might be different if it were a removal case. We're relying on that decision primarily for its extended and I think very thoughtful discussion as to why federal common law applies here. The Second Circuit obviously didn't have before it as a necessary issue the question of whether or not removal is appropriate, Judge Thacker, for the reason you say, because that case was filed initially in federal court. On that discrete issue, again, we're pointing to this court's case law in the Cottle case and the North Carolina case. And while Baltimore suggests in its brief that Cottle has been abrogated insofar as the Supreme Court has suggested that federal common law doesn't apply to that particular category of claim, I think Cottle is still very much good law, reaffirmed by the North Carolina decision, for the common sense proposition that where federal common law supplies the rule of decision, the claim necessarily arises under federal law for purposes of Section 1331. And once that's true, it would be nonsensical to say that removal is inappropriate because removal is coterminous with the existence of federal jurisdiction.
Yeah, but after Empire Health Choice, isn't that just dicta in Cottle?
No, I don't think so, because
what holding can you rely on to support your argument for removal? Because you started off with touting Cottle, but you finally got to Empire Health Choice. But is there much left of that case really that will help you in terms of your position? This case should be removed in federal court.
Yes, Chief Judge Gregory. And that's because, again, there are sort of two separate issues. The first is the question of whether or not federal common law applies in a particular context. The second question, and the one that I think we've just been discussing, is whether or not once federal common law applies, removal is appropriate. And on that question, I would point the court to the discussion, particularly at page 77 of the Cottle opinion. This is 999 F second. And at that point, the court says that, once a claim arises under federal law, because federal common law applies, removal is therefore appropriate. And so even if federal common law doesn't apply to that particular category of claim, which was obviously a very discrete category of claim involving federal health benefits, the point of Cottle is once federal common law applies, once it supplies the rules of decision, removal is appropriate. And again, I think the North Carolina decision, which obviously involves a quite different context of application of federal common law, and which postdates Grable, confirms that proposition. And we point to the decisions of numerous other circuits on that proposition. And I would point the court in particular to the Sam L. Majors decision from the Fifth Circuit that has the most extensive discussion on that point. And again, just to say one last thing about why federal common law applies in this context, and I want to get back to Judge Floyd's question. The reason that federal common law applies here is, again, not just because federal common law applies to claims of interstate pollution, which is a context in which the Supreme Court has said that the interstate nature of the controversy makes it inappropriate for state law to control. It's because in this context of global climate change, you have two additional factors. The first additional factor is that you have a state really attempting to project its regulatory policies outside its borders and doing so in a way that has not just interstate but international components. And second, this is a context in which there obviously is a significant federal interest in regulation. Global climate change is obviously the subject of international agreements as well as pervasive regulation by the federal government. And therefore, again, in our view, it follows a fortiori that federal common law applies. And we would point not just to the Second Circuit's decision in City of New York, but also to the Supreme Court's decision in AEP and the Ninth Circuit's decision in Kivalina. Judge Floyd asked about the other grounds for removal, and I just want to say a word in my remaining minute and a half about the other ground on which we primarily focused in our supplemental brief, and that is removal under OXLA. In our view, Baltimore's claims have a sufficient nexus with appellants' operations on the outer continental shelf to justify removal. And Baltimore doesn't really contest the key facts for that purpose, which are, first, that appellants are among the world's largest fossil fuel producers, but second, that a significant portion of their production takes place on the outer continental shelf. Instead, Baltimore's argument here is that appellants have failed to establish but-for causation between Baltimore's claims and appellants' operations on the outer continental shelf. Now, we think that the plain language of OXLA suggests that but-for causation is not required. We point to the Ford Motor Company decision from the Supreme Court, which involved a very similar test, albeit a test for personal jurisdiction, for the proposition that causation is not required under the OXLA statute, which provides for jurisdiction over actions either arising out of or in connection with operations on the outer continental shelf. And I would submit that when Baltimore's theory of harm is properly understood, and it's a theory of harm that explicitly and necessarily depends on the production of fossil fuels and the use of appellants' fossil fuel products, that the requisite nexus exists, really whether or not but-for causation is required. And again, we think that these two grounds provide the straightest course for this court to hold that federal jurisdiction is appropriate here. I see that my time has expired, so unless there are any further questions, I will.
Sure, Mr. Chairman, are you saying that basically any suit that would involve perhaps your ability to engage in exploration of the oil would be something that would be federal jurisdiction? Well, that could be any suit, right? Any suit where you got a large judgment against you would obviously have an impact on your operations because you may not have enough money to do what you do. I mean, that's a circular argument or self-fulfilling prophecy.
So, Chief Judge Gregory, 2 points. So, our first submission to the court is that because here the theory of harm explicitly depends on our production and all of our production worldwide, we think that there is OXLA jurisdiction. And I would point you to the Fifth Circuit's decision in United Offshore and the decision of the Western District of Louisiana in Superior Oil for evidence of just how broadly courts apply this principle. And I think that the law of the Fifth Circuit in this regard is instructive. These are cases involving, contractual disputes over who controls the operation of a gas pipeline or contracts for the sale of natural gas. Now, we have a second theory, as you'll be aware from our supplemental briefing, which is that the relief that Baltimore seeks would deter, if not render entirely impractical, any further production on the outer continental shelf. And I don't think that that means that any effort to impose liability on appellants is going to give rise to OXLA jurisdiction. It's just that the relief that is being sought here by Baltimore is so extraordinary, potentially billions of dollars in compensatory and punitive damages, disgorgement, and equitable relief, including abatement, that could provide an alternative basis for jurisdiction under OXLA if you reject our primary submission.
All right.
Okay, unless the court has any further questions, I'll reserve the balance of my time for rebuttal. Thank you.
Thank you, Mr. Shanmugam. Thank you. Mr. Shah?
Good morning, Your Honors, and may it please the court. There are two really remarkable absences from my friend's argument and from appellants' positions in their papers. The first is even a mention of the Ninth Circuit's decision in Oakland, which involved a case very much like this and is on all fours on the jurisdictional question. And the second is any appreciation of both this panel's prior holding about what this case is about and the actual allegations of the complaint. This court has already held that this complaint rests on defendants' lack of warnings and abetted by a sophisticated disinformation campaign. And that set of allegations which permeate the complaint in every cause of action provide a purely state law claim that is proven only by reference to state law. And in contrast to every case that my friend relies on, there is no necessary element of federal law, regulation, policy, action, conduct, contract,
What
or
about the
anything.
fact, as opposing counsel argues, that the impact of the complaint would exceed Maryland's borders, and in fact, the goal is the goal of the complaint appears to be to redress global climate change?
Well, Your Honor, let me take the second point first. The goal of the complaint sadly cannot address global climate change. It's focused very narrowly on a past pattern of conduct based on deception and failure to warn, and it seeks compensatory damages for injuries that flow from that past conduct. Policy issues, future forward-looking conduct are not part of either the remedy or the claims for relief. And
what about the fact that opposing counsel argued that Maryland, by this lawsuit, seeks to impose its regulatory standards beyond its borders?
Well, states are allowed to redress injuries for conduct that occurs outside of their borders when they injure the state inside the borders. That's well established. And in fact, even in the BMW v. Gore case, the court acknowledged that as long as a case is in pursuit of a state interest, that's a legitimate and an entirely appropriate thing. I think, Your Honor, that the notion of extraterritorial reach of a claim where in-state residents and plaintiffs have been injured is a misdirection. If you look at cases like Jackson from the Fifth Circuit about asbestos, says that a dispute cannot become interstate in the sense of requiring application of federal law merely because conflict is not confined within the boundaries of the state. And in the Agent Orange case, the Second Circuit said there is no federal interest in uniformity for its own sake. The fact that application of state law may produce a variety of results is of no moment. It is the nature of a federal system. And what these cases stand for is that where a state interest is at issue in a case, and the plaintiff, can put its case together without reliance on a federal issue, there is no federal removal jurisdiction. It's simply, there is nothing in our complaint that depends on a federal duty, law, regulation, or issue.
Well, Mr. Sheriff, let me ask you this. Does it give you pause that you have used the word production in your complaint, and that would go to the outer shelf? Wouldn't you be better off just to delete production from your complaint, and then I don't know what they'd have to fuss about then?
Well, they'd find something, I'm sure, Your Honor. The question for jurisdictional purposes is not whether there is a federal-based theory in the case, but rather whether there is a state court theory independent of that. And if you look at this court's cases, in cases like Dixon, where there was a state law claim and a First Amendment claim pled by the plaintiff, and the court said the First Amendment claim doesn't matter because they can succeed on their state law claim without it. The Pinney case, similar, there's many references to federal regulations. Flying pigs, despite the importance of patent law in the case, there's no significant federal issue that's necessarily raised. And actually in Burrell, Your Honor, in which you were on the panel, Judge Floyd, there was no jurisdiction, even though the federal Drug Administration regulations expressly preempted different and additional state requirements. And the court pointed out in that case that conflates the question of preemption with the question of jurisdiction, and North Carolina's cases are fully capable of applying federal preemption law. To the extent that there are federal issues, and I'm sure that my friends on the other side will raise them in motions to dismiss and in motions for summary judgment and probably otherwise, that involve federal preemption defenses, the state court will be entirely competent to hear them and resolve them. And as the Supreme Court made clear in the Manning case, it is an important principle of federalism to allow state courts to do that and not to appropriate that role exclusively to the federal courts. Oakland is directly on point. It would involve removal jurisdiction of a claim that is actually quite similar to the cities here. New York, on the other hand, by the Second Circuit's own description of what it was doing, was a merits case, not a removal case. And the other cases that my friend relied on, the Standard Oil case, for example, and the Swiss American case out of the First Circuit, those were in fact choice of law cases, but there was no question of federal court jurisdiction. Both of them had been filed in federal. That case, those cases rather, this case and the Ninth Circuit case in Oakland, which, as I say, is on all four. On exactly the theories that my friend is promoting here, and then dismiss the case on the merits. And the Ninth Circuit held explicitly that the only test to apply is Grable on the first hand or complete preemption on the other, neither of which supported removal. I wanted to offer a brief word about a theme in defendants' papers, which has to do with the focus on emissions as the source of injury here. And they bootstrap that up to this is an emissions case and therefore falls within the Clean Air Act or federal common law. And it misunderstands the tort at issue here. Our burden at trial will be to show that the failures to warn and the deception campaign were substantial factors in exacerbating emissions, making them greater and thereby exacerbating the harms. And if we don't meet that burden, we lose. But conversely, the fact that there are other factors or other steps in the causal chain does not determine that federal jurisdiction is exclusive. Let me say a word about Caudle in North Carolina. I think Empire did, as Chief Judge Gregory's question suggested, Empire did not leave much, if anything, of Caudle as a rule. But beyond that, in that complaint, the court found that the complaint on its face raised federal contracts and an intricate web of federal regulations for healthcare, and that those concerns and federal issues which were on the face of the complaint supported removal jurisdiction. In that sense, the case applied the well-pleaded complaint rule and is actually consistent with Grable. To the extent that it goes beyond that, it was limited, if not completely abrogated by the Supreme Court in Empire, which found that despite that extensive and thorough web of federal relationships that governed the plaintiff's claim, that there was not federal common law to apply. And the court famously said, there is no cause to displace state law, much less to lodge this case in federal court. So proximity to federal issues does not equate federal common law, and it does not support removal jurisdiction. Alcoa was very much the same. That's the North Carolina case that Mr. Shanmugam referred to, in that the claim to title on its face for submerged lands turned on a key federal issue, and there was no avoiding it. This court, in just last week in the Old Dominion case, found that earlier case law that predates Grable that uses the well-pleaded complaint rule and applies it can remain viable, and there's nothing inconsistent with Alcoa and this case. And by the way, Alcoa relied on Franchise Tax Board, the Supreme Court case that the court has later said was a predecessor to Grable. With respect to Oxla, just a quick word on that. There's no jurisdiction under that law because, similar to the court's prior holding with regard to federal officer removal, any connection between fossil fuel production on the OCS and the conduct alleged in the complaint is simply too remote. The injuries here were not caused by and do not arise from and do not interfere with any physical operations on the Outer Continental Shelf. And nothing in the Supreme Court's recent decision in Ford on personal jurisdiction, which construed different language having a different purpose, has any bearing on this jurisdictional provision. We think that the other issues have been dealt with well in the papers, and unless the panel has more questions for me, I'll be happy to sit down.
All right, thank you, Mr. Chair. Mr. Shanmugam, you have some time reserved.
Thank you, Chief Judge Gregory. Just 4 quick points. First, on the Ninth Circuit's decision in City of Oakland, we addressed that decision at pages 7 to 8 of our supplemental reply brief. But very briefly, we believe that that decision does not address the question of whether or not federal common law applies. Instead, it proceeds on the assumption, which we obviously think is an incorrect assumption, that claims arising under federal common law are not removable to federal court because they don't implicate either Grable or the complete preemption doctrine. And for the reasons that I gave in my opening argument, we think that that aspect of the Ninth Circuit's decision is incorrect. Second, my friend Mr. Scherer suggests that this court's prior decision in this case is somehow controlling of the issues that are currently before the court. Of course, that decision addressed only the federal officer removal ground for removal, precisely because, as the Supreme Court later told us was not true, the court under prior precedent believed that its appellate review was limited to that issue. But to the extent that this court in the earlier decision addressed this question of the appropriate characterization of the claims, we believe that the critical point here is that the complaint by its terms makes clear that whatever the theory of liability, and there are 8 claims in the complaint, the mechanism of harm is greenhouse gas emissions that take place worldwide. None of these claims can go forward without the plaintiffs establishing the use of fossil fuels worldwide as an element of their theory of causation. And the relief that is being sought here is much broader than my friend Mr. Scherer suggests. It's not just compensatory damages for past conduct, and it's not just compensatory and punitive damages. It's also disgorgement and equitable relief, including abatement of the nuisance. So Judge Floyd, to go to your question, the plaintiff here can't simply delete the references to production. References that I would respectfully submit are pervasive in this complaint, both in the body of the complaint and in each of the relevant claims. Again, the mechanism of harm, the theory of liability here is that production and use of fossil fuels worldwide resulted in the harms for which a plaintiff is seeking relief. And of course, for purposes of removal, if even one of the claims in this complaint can be characterized in the way that I've just suggested, then federal jurisdiction is appropriate. And at a minimum, with regard to the nuisance and trespass claims, again, exactly the same claims that were at issue in the City of New York, we believe that those claims cannot fairly be characterized as simply about misrepresentations. Third, Mr. Scherer suggests and talks at great length about whether or not there is a federal duty or whether or not there are regulations on point. that at most goes to the question of whether or not there is federal jurisdiction under Grable. And we obviously respectfully disagree with Baltimore on that point. But that doesn't really have anything to do with either the federal common law ground for removal or the Oxla ground for removal here. And so I just want to be clear that to the extent that the court is addressing those grounds, the question of whether or not there is somehow a federal duty or regulation on point is not dispositive. And finally, the last thing I would say is that it would be really problematic for this court to sanction what Baltimore is doing here, because it could result in 50 states each applying their own state laws to what is conceitedly a global issue, the issue of global climate change. And Mr. Scher and I were both present, albeit telephonically, at the Supreme Court arguments in this case, where the United States itself said, and I'm quoting, that the plaintiff in this case, quote, tried to plead around the court's decision in AEP, but its case still depends on alleged injuries to plaintiff caused by emissions from all over the world, and those emissions just can't be subjected to potentially conflicting regulations by every state and city. Our fundamental submission here is that these claims should be governed by a uniform body of federal law. That is precisely the context in which the Supreme Court has said that federal common law applies. And for that reason, federal jurisdiction is appropriate and the district court's remand order should be reversed.
Thank you so much. Thank you both, counsel, for a well-argued case and helping the court on these very difficult and complex issues. We wish you could come down and extend our hand to make clear how much our appreciation is, but we can't. But know, nonetheless, that it's just as much heartfelt and very much appreciated. And we wish you well and stay well and be safe. Thank you, counsel.
Thank you.
Good morning, Your Honor. May it please the court, Margaret O'Shea at the Attorney General's office on behalf of the appellants.
Yes.
It is uncontroverted that the Virginia Department of Corrections has held inmates in long-term administrative segregation, what the plaintiffs refer to as solitary confinement. It is equally established that the Department of Corrections has established and implemented a nationally acclaimed program for the express purpose of helping successfully transition these inmates back into the general population. When the program was started in 2011, there were 511 inmates in long-term segregation in Virginia. By the time this complaint was filed, that number had fallen to 37. Virginia prison officials reasonably relied on precedent from this court, both in putting inmates in segregation in the first instance and then establishing the step-down program to help move them out. They are entitled to qualified immunity as to the constitutional claims, and the district court erred in denying their motion to dismiss. There are two overarching principles of qualified immunity through which this court should make sure to view the facts of this case. One is that qualified immunity is more than a defense to litigation. It is an immunity from suit, an entitlement to avoid the burdens of litigation. The second is that cases being examined for qualified immunity must be scrutinized at the appropriate level of factual detail and not couched in overarching concepts of generalities and concepts of law. In other words, the determinative question is whether a reasonable official could have believed that their conduct was lawful in light of clearly established law and the information the defendants possessed. It protects all but the plainly incompetent or those who knowingly violate the law. Looking at the facts as alleged in this particular complaint, a reasonable corrections official could have believed that the conditions of confinement at Redden State Prison and the procedures offered through the step-down program were constitutionally sufficient.
So would that be true even after Porter versus Clark?
As to the Eighth Amendment claim, perhaps, Judge Thacker. The defendants take the position here that Porter decided after the filing of this complaint is not determinative on the qualified immunity analysis. And as a panel of this court recognized, that, in the Latson opinion, Porter changed the state of the law in the circuit by recognizing for the first time a basic human need for meaningful social interaction and positive environmental stimulation.
So if Porter was the law I understand your argument that it was obviously after the fact, but if Porter were the law at the time of this alleged violation, does the state concede that the allegations are sufficient to establish Eighth Amendment conditions of confinement violation?
Well, so the inquiry, no, in short answer. And long answer, the inquiry is not whether they've plausibly alleged an Eighth Amendment claim. It's whether a reasonable corrections officer looking at these allegations could have thought that the conduct conformed to the Constitution.
So even now, after Porter, the state's argument is that a reasonable officer wouldn't view these allegations as a violation, even after Porter?
Yes, not necessarily. And the reason for that is because the conditions at Porter and the conditions at issue here are not analogous. The inmates in Porter were placed in death row by virtue of their sentence and their sentence alone. They had no way to transition out at all. And when you look at the various privileges and opportunities that are afforded under the step-down program, it expands the conditions of the confinement. It makes them less draconian than those that this court addressed in Porter. In addition to that, the inmates in Porter only had 1 hour of out-of-cell recreation per week. At the time this complaint was filed, all inmates held at level S, all of them, regardless of pathway, security level, so on and so forth, had at least 2. I understand the court doesn't want to do a side-by-side comparison of the conditions necessarily, but twice as much out-of-cell time when you combine that with the other opportunities in the step-down program for group programming, for therapeutic programming, for work opportunities. It suffices to make the conditions at Red Onion State Prison less restrictive than those that existed at Sussex One State Prison and Death Row and were at issue in Porter. But that said, the determinative law here should be up until the time of the filing of the complaint. The issuance of Porter.
Ms. O'Shea,
Yes,
in terms of the Eighth Amendment, it doesn't prohibit cruel and unusual prison conditions, but rather the question that we should ask is whether the confinement inflicts harm objectively sufficiently serious to deprive a prisoner of minimal civilized necessities. They have clearly pled that harm in this case, as opposed to some of the other cases just talking about conditions. Here is the result and the harm inflicted. Why did that get them by the immunity question?
I understand, Your Honor. So the harm that they have alleged here, the deprivation of the meaningful social interactions, the ability to interact with other people, had not been recognized by this court up until the Porter decision. Case after case after case in this court had held that just not being allowed to be around other people, even if it resulted in negative mental effects, was not sufficiently serious to constitute an Eighth Amendment violation. As recently as 2012, in the Williams v. Branker decision, a panel of this court upheld the granting of a motion for judgment on the pleading, saying that the negative effects of restrictions in solitary confinement on an inmate's mental health are not enough to constitute the extreme deprivations required to make out a conditions of confinement claim. That case is notable because it came down in 2012, contemporaneously with the issuance of the step-down program by these defendants. A reasonable official looking at established law could have believed that the conduct here was lawful, at least up until the time of the Porter decision, which was issued after the filing of the complaint. Qualified immunity is an immunity from suit, and it should be judged as of the filing of the suit at the very latest. So for that reason, the court erred in denying the Eighth Amendment qualified immunity. Turning to the due process allegation, when you look to the various procedures and multiple layers of review that are afforded by the step-down program, a reasonable official looking at this policy could have believed that it afforded inmates a meaningful pathway out of segregation. When you consider the information that was publicly available to these corrections officials, with 511 inmates transitioned all the way down to 37. And then when you look to the policy and the multiple reviews that are made available through not only the informal 30-day reviews, but the quarterly reviews by the dual treatment team, the biannual reviews by a team external to the prison, the yearly ICA reviews, the 90 formal due process reviews, those multiple layer reviews, some of which also apply for appeals, some of which the ICA hearings require advance notice and an opportunity to be heard, a reasonable official looking at this policy could have believed that it satisfied the dictates of due process as spelled out by Wilkinson and as later interpreted by this court in Incuma and the subsequent decisions.
Well, Ms.
So
O'Shea, that I'll give you that policy looks really good on paper. The question that we should ask as to whether or not there's immunity is in practice. Was this policy followed, and more than just checking a box and walking by a jail cell? I mean, that can't possibly count as meaningful review.
I understand the court's question. Here, the plaintiffs have not really challenged any specific individual procedural view that they say failed to follow the policy. They're saying the policy as a whole, because this action is brought against the policymakers. It wasn't brought against the individuals who go through the housing unit and apply the policy. The policymakers looking at the policy would not have had any reason to think that the procedures spelled out here don't provide a meaningful pathway out of segregation, and nor have the plaintiffs sufficiently alleged those facts in their complaint. It's their burden to allege sufficient facts to show that the process was not meaningful and that the policymakers should have known that the policy was not meaningful. But when you consider the knowledge of the policymakers, the enormous number of inmates that transition through the step-down program, and not just that, but other external sources as well. This court called the step-down program a sophisticated, well-conceived program to better behavior and improve the safety and operation of the prison. The Department of Justice acknowledged specifically Virginia and what a great job Virginia was doing in the implementation of this program. The Vera Institute of Justice did the same. So source after source, not just the courts, but sources external to the courts, told the Department of Corrections that what they were doing was laudable. And then for them to later be denied the benefit of qualified immunity for this nationally acclaimed program that had been subject to all of these accolades, it would be unconscionable. Any reasonable official looking at the step-down program and the conditions of confinement that it imposed would have believed that the conduct both in putting inmates in segregation and then establishing this program to allow them to transition out was lawful, that it complied with the dictates of the 8th Amendment, that it complied with the dictates of the 14th Amendment. Corrections officials are not supposed to be able to predict the future course of constitutional law. They are not constitutional scholars. They are lay individuals, and a lay individual, knowing what these officials knew, would not have believed that their conduct transgressed the federal constitution. Unless the court, yes,
counsel, you said anybody looking at the program, like Judge Floyd said, I mean, it looks pretty good. I mean, but the question is, so first of all, we don't make determination of facts. You understand? We in the Fourth Circuit, we say that's sort of jurisdiction of the qualified immunity of facts to be determined. We don't do that here, correct?
The court is entitled to look at the facts as known to the officials. Does the court engage in specific fact-finding, resolving credibility issues?
It's not just, it's known or should be known. And if those facts are in dispute, we don't make the determination to resolve those disputed facts, correct?
Well, so the qualified immunity analysis doesn't require the resolution of disputed facts. It's a reasonableness objective.
Sometimes it does. I'm saying when it does, we don't make that decision at this point, right? We don't resolve the disputed facts.
The court doesn't resolve disputed facts. What the court does is look to the factual allegations of the complaint. Look to facts that are subject to judicial notice. If there is a conflict between facts and a policy that's appended to the complaint and made a part of that complaint under Federal Rule 10C, the attachment prevails over the bare, unsubstantiated allegations in the complaint. That's not resolving a disputed issue of fact. That is looking to the actual policy.
Well, they allege that you come with the procedure is already pre-filled out forms. It's rote. It's the same thing. And you talk about past conduct. You're really not assessing what their actual present or contemporary behavior is. You don't use. There's no penological justification for it. You don't use compass as you do for general population and all of these things that'll be empirical to determine it, you don't even use those. That's what they're alleging, that you have something that you put it together and put a ribbon on it, it sounds good, but you got to open the box up first and see what's in it. And their allegations are, it is nothing. It is really rote. You stay in, and you put the process together. Even if you put the process together, so you have noticed if you're not following it, you would know that if you have predetermined, already filled out forms and everybody gets the stamp, denied. That's what they're alleging. And so you said we had ignore those facts and just say because you have a policy attached to it, we have to then say, oh, there's a policy there, so they must be wrong about their facts they allege.
I'm alleging that they have not sufficiently alleged that these defendants were or should have been aware of any deficiencies in the program. They have not brought this suit against the unit managers or the counselors.
Wait a minute. If because we don't sell it, but wouldn't you know if you already predetermined form before you have a hearing and review? Wouldn't you know that?
But
I'm asking you a question. No. Ask a question. If you are the official and you know before the hearing you already have a pre-filled out form saying denied, wouldn't you know that?
If you are the person conducting the hearing,
but
not if you're the person who wrote the policy, they're different.
But there are more. You got a building management process committee. These are not just policies. These are people. It's a systemic claim. It's not just someone who wrote the policies and, well, I wrote the policy, I don't know anything about it. But these are the functionaries who carried out their alleged. You can't divorce the case solely from, well, somebody in the Ivy Tower wrote this, and unless you can say they peeped back at this policy, they wouldn't know. No, they're saying systematically, this is nothing but a farce. You come up there, you don't even look at what they've really done. You look at their historical behavior and say, denied. It's already filled out form. I'm not saying it's true, but that's what they're alleged. And you're making this is hermetically sealed and you not to be permeated at all by their allegations just because you have a policy. How could that be?
It's the question, but before the court isn't necessarily whether they have plausibly alleged a due process allegation. The question is whether a reasonable corrections official looking at established law could have believed that the policy survived constitutional muster. It's a reasonableness and objective standard. And you look not just to the policy, but 511 inmates to 37. That is information that they knew and were entitled to consider when evaluating whether the step-down program satisfied the dictates of the due process clause.
Ms. O'Shea, this case is before us on a motion to dismiss, and it certainly the pleadings have a bearing on the question. For example, the complaint alleges that during the relevant period, each defendant participated in creating, administering, or implementing the step-down program, or failed to properly diagnose and treat the plaintiffs suffering from harms. I mean, why is that sufficiently pled to get them by a motion to dismiss?
Because I see that my time is expiring. Is it?
You may answer the next question.
So, because Your Honor, the question is not just whether they've plausibly alleged a due process violation, it's whether a reasonable official looking at those allegations could have thought that the program was okay. It's separate and the two should not be conflated. And missing from this complaint, in addition, are allegations that would support the reasonable inference that the policymakers should have known of the deficiencies in the program. It is their burden to put those facts in the complaint to support their ultimate conclusion, and they did not do that. It is not unprecedented for this court to uphold a finding of qualified immunity in the context of a motion to dismiss on a Rule 12b-6. In fact, the parole board decision that Your Honor wrote back in 2014, Burnett v. Fahey, did exactly that. Upheld the finding of qualified immunity as to a due process claim raised at the Rule 12b-6 motion phase.
But it's not just the policymakers; it's the boots on the ground, and they are alleging that the boots on the ground weren't doing what they were supposed to do, and as a result, they've been harmed. So if they can prove that, maybe at the summary judgment stage you get relief on qualified immunity. But if they can prove what they say, I don't see how you can get by, prevail on qualified immunity?
Because the boots on the ground are not defendants in this case, and respondeat superior does not apply in actions under Section 1983. I would like to reserve the remainder of my time unless there are further questions from the court.
Well, that goes back to my question, that it looks good on paper, but they're alleging in practice it just is not working.
This paper is important here because of the objective reasonableness standard of qualified immunity. Thank you.
All right, thank you.
If there are no further questions, I'll reserve. Thank you.
Yes, certainly reserve, yes. Counsel, Agra-Harker.
Thank you, Judge Gregory. Good morning, Your Honors, and may it please the court. Vishal Agra-Harker for the plaintiffs. I will be, am I muted?
No, I can hear you.
You can hear me? Okay, great. So I will be spending the first half of our time addressing the Eighth Amendment claim today, and then my co-counsel, Andre Popovici, will be addressing the due process claim. Your Honors, plaintiffs were held in a program that they allege was designed to warehouse people in conditions that defendants knew put them at risk of severe and often permanent mental and physical harms, and that served no legitimate penological purpose. Now, taking those allegations as true and not the alternate set of facts that defendants put into their briefing, no reasonable official could have believed that it was constitutional under the Eighth Amendment to implement a program to keep people in conditions that they knew to impose such harms. And this is especially true in light of this circuit's precedent in cases like CityNet and Thompson and others, that qualified immunity does not protect government officials when they violate the law with actual knowledge of a risk to constitutional or statutory rights. And that's precedent that defendants didn't address in their briefing and didn't address here today. I would like to first address why the law is relevant to our allegations was clearly established long before Porter. I'll then touch on the Williams versus Branker decision, which defendants put into their reply and that we haven't had an opportunity really to address fully. And I want to finally just touch on our alternate theory of relief under the Eighth Amendment for wanton infliction of pain without a penological purpose, on which the district court also very clearly denied qualified immunity. Onto the first point, plaintiffs acknowledge that long-term segregation on its own, without a showing of serious harm, was not clearly established as unconstitutional, at least until Porter, a case that granted summary judgment to plaintiffs on their Eighth Amendment claim about the conditions on Virginia's death row, without any finding in that case that the plaintiffs had in fact been harmed. But that's different from what we allege. And in fact, it was clearly established long before Porter that the types of conditions in this case, either alone or in combination, can give rise to an Eighth Amendment violation, but only if they actually pose a serious risk of mental or physical harm to prisoners. Thus, in Williams versus Griffin in 1991, this court said, quote, that a totality of prison conditions can be combined to show an Eighth Amendment violation is a proposition established in many cases. And there the court found that overcrowding—
So your focus is on the harm rather than the condition of confinement?
The clearly established law, well in advance of Porter, said that conditions of confinement, including the types of conditions of confinement in this case, would violate the Eighth Amendment where they combine or by themselves, in fact, pose a serious risk of harm. And in this case, we're alleging—
So then wouldn't it be that some defendants in the same confinement conditions, there would not be a violation if they weren't harmed, while others in the same confinement condition, it would be a violation because they suffer harm?
That's right. That's right.
Well, that can't be— that's not very clear then, is it? I don't think. Well, it depends on the inmate's susceptibility.
Well, it depends on whether they've in fact, all the cases have said that Strickler, Sweet, all the cases the defendants cite going back to the 70s said that isolation by itself, and we agree, by itself doesn't render segregation unconstitutional absent actual harm. So whether it's isolation, whether it's limited restrictions on exercise, there are a virtually infinite set of different kinds of conditions that you might be subjected to in prison. And unless you are actually harmed by them, and not just harmed, but face a severe harm, so whether it's mental or physical, you can't state an Eighth Amendment claim because you can't satisfy the objective prong. Now, that principle has been clearly established for decades, but that principle, in light of what the district court found that we've plausibly alleged about defendants in this case, specifically their awareness of the harmful effects of the conditions in a program that they designed to warehouse people indefinitely through the kinds of sham procedures that my co-counsel will be addressing on the due process side, and for no good reason, for no penological purpose, other than, as we allege, to fill prison beds and unused prison beds in these two prisons. Given that knowledge that we allege in a nearly 100-page complaint about the history of the development of the step-down program and how it came after several repeated failed experiments by the DOC to set up earlier programs that other state agencies had found were developed after the DOC disregarded medical recommendations. These are very different types of allegations from the typical solitary confinement case, where plaintiffs often don't plausibly allege harm to themselves or defendants' awareness of those harms. And the fact that individual plaintiffs in other solitary cases could not make out a showing of serious harm to themselves at summary judgment in almost every case is not a reason to dismiss this case on qualified immunity grounds at this stage. Of course, defendants will have another opportunity to assert qualified immunity at summary judgment. Now, opposing counsel did mention, and I think maybe this gets to your question, Judge Thacker.
And it's your position then that Porter and Latson did not change the landscape at all in terms of this case and the allegations in this case?
Not in terms of this case. So I think Porter would put prison officials on notice that long-term solitary conditions on their own pose a substantial risk of harm. So after Porter, it might be easier for a typical solitary confinement plaintiff to say, who's alleging that their conditions caused them harm, to hold a warden of a jail responsible for the conditions in their equivalent of long-term disciplinary set. But even before Porter, it was established that if a person was placed in conditions that would in fact cause them serious harms, that would be unconstitutional. And given our what the
so you're saying that Porter changed nothing in terms of the allegations in this case?
That's right. Given the clearly established inquiry has to be undertaken in light of the specific allegations in the case. And here, and so I think your Honor's question maybe goes to the specificity of the inquiry, whether we're looking at it at too broad a level of generality. And the qualified immunity inquiry is fundamentally concerned with notice and whether the case law and the specificity is needed to the extent that it is required to put reasonable officials on notice that their conduct is prohibited.
I guess I'm actually backing up a little bit, trying to get a handle on what you allege the violation to be in this case versus what Porter found the Eighth Amendment violation to be.
Our allegations are about the design and implementation of a program to warehouse people indefinitely in conditions known to cause harm by essentially policy-making officials who are developing a policy to create a program that would keep people indefinitely in conditions that they knew. These were high-level policy-making officials who had the awareness of the scientific consensus that had emerged in the lead up to 2012 when the program was implemented, and had that awareness based on their own past failed attempts at establishing solitary confinement in their precursor programs. So it was more about the design of the program itself, rather than the typical case.
But before Porter, in the Fourth Circuit, long-term solitary confinement did not violate the Eighth Amendment.
Long-term solitary confinement per se did not, no. But our allegations are essentially about putting people in conditions that you knew would harm them. Designing a program to warehouse them in conditions based on clearly established law saying that you cannot put people in conditions that would in fact pose a serious risk of harm, that was sufficient. And it's especially true in light of this principle in throughout several cases in this circuit's precedent, saying that qualified immunity doesn't protect government officials when wrongful intent is central to the underlying claim, as it is with respect.
Is this the harm? Is that an objective or subjective question?
Thank you, Your Honor. It does go to the objective prong because it goes to whether their awareness goes to whether it is fair to say that they had noticed that the objective prong was met. So yes, it goes to subjective prong. This case right at this stage is about the objective prong, but their awareness of the harms caused goes to whether they were sufficiently on notice under qualified immunity standards. And so looking at, I see that my time is up. May I complete the thought, Your Honor?
Yeah, you may complete the thought, and I have a question for you before you sit down. Complete your thought.
So given the case law in CityNet and Thompson and Dean, that when you're violating the law with actual intent, with wrongful intent, then qualified immunity is inappropriate. That applies at this stage to our claim just as strongly, if not more strongly, and certainly more strongly than the typical solitary confinement case that this court has seen.
I want to go back to Judge Thacker's good question, because it may make it clear. And this is more of a, I want you to clarify for me. Now, you said before Porter, it was understood that mere separation did not give rise to a cause of action, Eighth Amendment, correct?
Right. Just being
mere
segregated.
Separation, but let's just call it separation.
Exactly.
That aspect of seg, and that's what the very name of it is to be segregated, to be separated. So mere separation before that was not enough. They would not be on notice for separation alone being the effect of segregation, correct?
Not merely segregation, but many other types of prison conditions, because the key is whether they in fact cause a serious harm. But yes.
All right. So what then in your case is more than separation that somebody would be on notice of pre-Porter? I mean, explain the divide somewhere in terms of your case, how, notwithstanding that separation was not a cause of action before that in the Eighth Amendment, how would they have known that before that case that what was doing here was more than separation or exposure to dangers? Explain how is that?
I think one way to answer this question is to look at a case even from the 1970s that actually laid out that principle. Sweet. It said isolation by itself doesn't render segregation unconstitutional absent other illegitimate deprivations. But even in that case, the court remanded to the district court to determine whether just one aspect of that may have been harmful to a prisoner's health, and if so, would amount to an Eighth Amendment.
Would you repeat? You froze on us.
I apologize, Your Honor. I said even in Sweet, the court, in fact, remanded to the district court to determine whether just one aspect of segregation, prolonged restrictions on exercise, would in fact be harmful to a prisoner's health, and if so, would amount to an Eighth Amendment violation. Strickler, Sweet, all stood for that same principle. And given our allegations that in this case, these high-level policymaking officials knew that the specific conditions that they were putting people in were in fact harmful.
And what was that? There was more than separation. Go ahead, follow.
In Sweet, it was.
Oh, in your case, this.
Oh, in my case. Well, so the court found that we have alleged a variety of serious harms. So the defendants haven't actually challenged that we have stated a violation, only that the law was not established. But specifically, the harms include, for example, post-traumatic stress disorder, schizoaffective disorder, major depressive disorder. There are many that are listed for the various plaintiffs. And so those are the kinds of actual injuries. So it's not, you can't look to just the specific condition, whether it's inadequate ventilation, lack of exercise. You say, well, did those cause injuries? Our allegations at this point are that they knew that they did, and yet they did it anyway. And that also goes to our second theory of relief. You can't knowingly harm people for no good reason.
And how did they know that they did? Was it because of the scholarly research?
It's based on the consensus that had developed about, in the lead up to the development of this program. It's based on their own repeated failed attempts at setting up earlier programs where another state agency had found that they consulted with and then disregarded recommendations of other officials. It's based on their own experience with people in long-term segregation.
What is the difference between the conditions of confinement in Porter and the conditions of confinement alleged here that make it different from Porter and clearly established as a violation before Porter?
Your Honor, so by my reading, they are highly, highly analogous. Most of the this is the first time the defendants have raised this point that even Porter wouldn't put people on notice that these conditions weren't constitutional.
Well, if they're highly, highly analogous, the conditions in Porter and the conditions in this case, how then was the violation clearly established prior to Porter?
Because of our allegations about their knowledge of the specific conditions that existed in the step-down program, in fact, satisfied the objective prong. At this stage,
in this case, you have sensory deprivation, which was not considered back in the 70s. I mean, clearly there's literature and science that sensory deprivation causes extreme harm to folks.
That's absolutely right. And that consensus developed over time, but was clear by 2012. But what was established just in the law was that if you know you're putting someone in conditions that would seriously harm them, then that's a constitutional violation under either theory of relief. And that's what, at this stage, is clear.
So your allegation that they knew that beyond separation, they were doing harm. That's what your allegation.
Essentially, that's exactly right, Judge Gregory. That's what the district court plausibly found in this case that he didn't find in each of the Red Onion cases that defendants cite on page 32 of the brief. That was the distinction. In those Red Onion cases, he said, well, they haven't plausibly alleged harm. Yes, these were pro se plaintiffs who
right. And how is it that they knew that they were causing harm? I'm sorry, I really want to understand. I really do want to understand your argument.
No, thank you, Judge Thacker. And I want to be as clear as I can. I guess two things. One, defendants, again, have not actually challenged in their briefing that we have stated a violation. They've only challenged, and we fleshed out on page 22 and 23 of our brief, they've only challenged whether the law was clearly established. Our allegations are that they knew based on the consensus, and of course, this is the Eighth Amendment, it looks to the evolving standards of decency, based on the consensus that had emerged in the lead up to 2012. I think one of the amicus briefs by psychological officials also kind of lays this out, as well as their own failed experiments with the step-down program, or with precursor programs to the step-down program where they consulted mental health professionals and then disregarded their recommendations, and then their own experiences with people in this program, in their various programs of long-term solitary confinement, and seeing that themselves.
Well, let me ask you this. Would you agree that this analysis is a two-step analysis, and it appears to me that the state of Virginia is trying to trying to prevail on step one without going to step two, and in this case, you have pled both steps. Is that correct?
We have pled both steps. The court found that we have on the Eighth Amendment claim, the district court found that we have sufficiently pleaded an allegation, both as to the objective prong and the subjective prong, and then they found that the law was clearly established. Defendants, with respect to the Eighth Amendment claim, only challenged that second step of the clearly established inquiry, meaning that the law wasn't clearly established. If that answers your question, Your Honor.
They haven't challenged that they were doing harm. harm was caused. Correct?
They haven't challenged in their briefing, they have not challenged that the court's finding that with respect to, for example, they haven't said, I think Ms. O'Shea mentioned that, well, you have to show the harm with respect to each individual defendant. They didn't make any of those challenges in their briefing or challenge that we have adequately stated a violation. They only said that, well, the law wasn't clearly established because Porter came out in 2019. And so that's what we focused our briefing on.
All right.
Unless there are other questions, I'll allow my co-counsel to begin.
Okay, Mr. Propavici.
Good morning, Your Honors. Andre Popovici for the plaintiffs, addressing the due process claim. Your Honors, the complaint alleges that the defendants designed and administer step-down as a system of periodic reviews that has kept plaintiffs in solitary confinement for 2, 4, 6, even 8 years or more. But step-down doesn't give plaintiffs notice of the grounds for keeping them in solitary confinement or an opportunity to rebut those grounds. What step-down does give them is a system of pretextual reviews that keeps them in indefinite solitary confinement through unfettered discretion over decisions governing their eligibility to step down, preordained rubber stamp reviews, and having past conduct dictate permanent conditions of solitary confinement for some. Plaintiffs had a clearly established liberty interest in avoiding the conditions of their confinement under Wilkinson and Nkuma, and the reviews they received violated their clearly established due process rights under Wilkinson, Nkuma, and Hewitt. First, I'd like to address why the defendants are wrong that documents outside the complaint prevail over plaintiffs' allegations. Next, why it was clearly established that plaintiffs had a liberty interest. And finally, why it was clearly established that step-down reviews don't provide due process. Defendants spend much of their reply brief and arguments today asking the court to disregard plaintiffs' allegations about VDOC policies and practices in favor of their own interpretation of cherry-picked provisions in those policies and other irrelevant or extraneous information. The complaint's allegations, though, aren't just based on the text of VDOC policies. They're also based on the deposition testimony of VDOC officials in other litigations, as well as extensive interviews with prisoners as to how those policies are interpreted and applied in practice. Sometimes practice tracks the text, sometimes it fleshes out what's vague and not apparent. So VDOC policies can't be construed in the defendant's favor to defeat the complaint's allegations. It's well established that this court declines to take judicial notice of a party's interpretation of the contents of documents attached to the complaint when the parties clearly and reasonably disagree about the meaning to be ascribed to them. And judicially noticed facts are construed in the light most favorable to the plaintiff, along with the well-pleaded allegations of the complaint. Your Honors, none of the defendant's arguments that VDOC policies directly contradict the allegations in the complaint actually hold up under scrutiny. To give one example, the defendants say the complaint's allegations about minimum periods in the IM pathway are contradicted because they are unsupported by VDOC policies. But the minimum periods come directly from the VDOC policies in the record, which say that IM prisoners must spend 6 months continuously in each of phases 0, 1, and 2, and must spend a minimum of 12 months in IM closed phase 1 before progressing to IM closed phase 2. That's a JA 161, 186, 188, and 207. In deposition testimony in another litigation, VDOC's Rule 30b-6 representative confirmed that IM prisoners can't be considered for advancement before these required minimum periods. As another example, the defendants have argued that VDOC policies contradict the allegation that the only way a level S prisoner may earn a lower security level is by completing the step-down program. But they don't cite any policies plainly contradicting our allegations, which are not only based on the text of the policies, but also deposition testimony on VDOC practice. In short, the defendant's attempts to ignore the complaint's allegations must fail. Your Honor, the plaintiffs also had a clearly established liberty interest in avoiding solitary confinement. The facts alleged in this case are materially indistinguishable from those in Wilkinson and Nkuma. As to the severity of plaintiffs' confinement conditions, the complaint alleges the same conditions of extreme isolation and severe restrictions as in Wilkinson. This court in Nkuma found that similar conditions were in fact worse than in Wilkinson, given the highly intrusive strip searches that prisoners go through every time they leave their cells. As to the indefiniteness of those conditions, in Wilkinson, there was no indication how long prisoners could be held in the Supermax facility once assigned there. Step down also provides no indication how long prisoners will stay in solitary confinement. There are only minimum periods, no maximums, and the plaintiffs have been there for over 6 years on average, an indicator of the indefiniteness of their confinement. For prisoners on the IM pathway, VDOC policies create permanent conditions of solitary confinement. As to the collateral consequences, as in Wilkinson, plaintiffs in step down are denied parole they would otherwise be eligible for. And as the plaintiffs allege, and as this court also found in Smith, being in step down can reduce or deny the opportunity to earn good time credit towards sentence reduction. Nkuma also found that collateral consequences weren't necessary to give rise to a liberty interest, given the other similarities to Wilkinson. Defendants haven't even disputed that plaintiffs had a clearly established liberty interest at the very latest by this court's 2020 decision in Smith versus Collins. That case is also dispositive here since the complaint alleges conduct that continues today. But Smith didn't change the law, it simply applied the law clearly established by Wilkinson and Nkuma to the step-down program. Finally, Your Honors, step-down reviews violated plaintiffs' clearly established due process rights. Wilkinson and Nkuma recognized that core due process protections to protect the liberty interests of prisoners in administrative segregation are notice of the grounds for the decision and an opportunity to rebut those grounds.
Okay. Does Wilkinson hold that notice, opportunity, rebuttal, and appeal procedures are required, or only that they were sufficient in that case to satisfy due process?
Your Honor, Wilkinson held that they were sufficient in that case to satisfy due process, but it also recognized that those protections were among the most important procedural mechanisms to avoid erroneous deprivations of liberty and essential to guard against arbitrary decision-making, to give prisoners a basis for objecting before the next decision maker, and to serve as a guide for future behavior. And Nkuma added that the prison's interest in order and security does not eclipse a prisoner's well-established right to receive notice of the grounds for his ongoing confinement and to present his rebuttal to those grounds. Your Honors, the plaintiffs don't receive those minimal protections here. First, the BMC decides every month if prisoners meet the requirements of the step-down program and can move up to higher privilege levels within level S, such as from SMO to SM1. These decisions are final, prisoners can't appeal them, and prisoners don't get access to them. Then the ICA
Isn't there a periodic review?
Yeah, so the ICA decides every 90 days whether prisoners can move down from level S to level 6. But these security level decisions depend entirely on the BMC's privilege level decisions. And at the ICA's so-called formal due process hearings, which are held at the prisoner's cell door in last only moments, prisoners are handed...
Counsel for the state said that since 2012, the population in solitary confinement had decreased from more than 500 to, I think she said 37. What does that do to your argument about whether or not the procedures in place are actually meaningful or not?
Well, Your Honor, it's well established that judicially noticed facts like that are construed in the light most favorable to the plaintiff. The complaint also points out that VDOC's statistics are misleading as they omit prisoners in the IM SL6 closed pod who face materially the same conditions. That's at JA 85 and 101 to 102.
So in the light most favorable to the plaintiff, those statistics are misleading. They don't say anything about the efficacy of the procedures in place at the step-down program?
Yes, Your Honor.
What you're saying is that in that number of 500 might include people who are stepped down, but their conditions are no different really than the other. Is that what you're saying?
Thank you.
Yes, Your Honor. And also, before this case was filed, the named plaintiffs had been in level 6 for an average of 6 years. Since this case was filed in May of 2019, several of our named plaintiffs were suddenly moved to general population or transferred out of the state. This court noted in Smith its skepticism about arguments that Smith's solitary confinement under the step-down program wasn't indefinite when the court noted he was only able to achieve progress in step-down after he filed the lawsuit, after which he was inexplicably jumped 3 steps from SMO to SM SL6. Your Honors, at the ICA's so-called formal due process hearings, prisoners are provided pre-prepared ICA decisions with conclusory rationales such as needs longer period of stable adjustment. These serve primarily to document whether the BMC has allowed them to complete the step-down program. As in Nkuma, that's not a factual basis. Plaintiffs only receive a perfunctory explanation that rubber stamps their status, listing the same justifications in rote repetition, and that practice encourages arbitrary decision-making. And as in Nkuma, there's no right to contest the factual basis for detention since the ICA has already made its decision, and the lack of reasons means the prisoner has no basis to object. And although the DTT every 3 months and the ERT every 6 months also do informal reviews, there's no suggestion in defendants' briefs that they provide any reasons. Indeed, the defendants haven't disputed that step down in fact fails to give any notice of the grounds for prisoners' ongoing confinement or an opportunity for rebuttal. The entire system of reviews is also not multi-layered because plaintiff's ability to step down depends entirely on the BMC decisions that are final and not reviewable. Your Honor, I was also going to explain why step down also denies the right to non-pretextual reviews. Since Hewitt, prison officials have been on notice that administrative segregation may not be used as a pretext for indefinite confinement. The complaint alleges that step down by design and as implemented gives plaintiffs pretextual reviews that keep them in indefinite solitary confinement. In view of the time, though, unless you have any further questions. For these reasons, Your Honors, we ask that you affirm the decision below.
Thank you so much, counsel. Appreciate your argument. Ms. O'Shea, you have some time reserved.
Thank you, Your Honor. Returning to the Eighth Amendment question, it bears emphasizing that qualified immunity is a reasonable person standard. It is not subjective. That the point of qualified immunity is to allow officials to conform their conduct to then existing law. And so the law must their conduct, that what they were doing violated the right asserted. The focus is not on alleged resultant harms or other subjective elements. It's on the objective reasonableness of the conduct as alleged in the complaint. As Judge Thacker noted, and as Judge Gregory, you as well, the conduct alleged here is not so different from what was upheld in multiple prior opinions from this court that every reasonable corrections official should have known that what they were doing violated the law. And this is true even in Eighth Amendment cases that have an objective and a subjective element. The focus is not on the subjective allegations, it's on the objectivity. What exactly are they alleged to have done? Were they clearly on notice that they can't do that based on the law of this circuit? And the answer in the Eighth Amendment context is no.
Ms. O'Shea, let me point you to something I think is very critical. Judge Thacker zoned in on it a couple of times, and the focus of that is in terms of knowing that harm was done. And for example, and you don't have to look at this, but you can look at it on JA 105, it's alleged that the VDOT, their policy requires ongoing solitary confinement of prisoners who exhibit symptoms of apathy, lethargy, attention deficits, poor grooming, and failure to maintain an orderly cell and failure to complete challenge of the 8 series book. Well, it seems like the fact that what it is, the harm that's being caused is the same things that make you not qualified to get out. And those things are cited as reasons to continue. So in that absolutely, it's a vicious cycle. It's like the results of our holding you in these conditions are also the things that make you not eligible to get out. Isn't that the ultimate vicious circle? You follow what I'm saying? And these are the things that are consistent with long-term deprivation harm, apathy, lethargy, attention deficit, failure to do your own personal grooming, to take their, that's what a person would likely do in terms of Judge Floyd was talking about sensory deprivation, contact with a human being. That's what happens to you. But you, not only does it not account for that and address that harm, but it says that's why you have to stay here, because you're doing what people normally do when they have this kind of harm. That's isn't that interesting that you, how do you address that?
Well, so I understand that that's their allegation, Your Honor, and that may very well be.
Aren't we dealing with allegations at this point?
Well, those are allegations that bear on the subjective element of the Eighth Amendment analysis. This court had held as recently as 2012 that negative effects of restrictions on mental health are not enough to constitute an Eighth Amendment violation, and the defendants were entitled to reasonably rely on that pronouncement of the law when deciding to retain individuals in segregated confinement.
That case says that if you know you're creating that harm, that wasn't enough. Or just said that having that harm was not enough. Here, they're alleging you knew because it was in your process to look for it, find it, and then find them not qualified to get out.
I'm not sure that I see that exact same conclusion from the allegations in the complaint, Your Honor.
Well, all right.
The focus is on the objective reasonableness of the conduct, not the subjective knowledge of these specific defendants. The Ninth Circuit very recently teased this out in an opinion talking about an Eighth Amendment medical indifference claim, and they said you don't look to the allegations that bear on the subjective knowledge of the defendants. You look to the objective reasonableness of the defendant's conduct to ensure that the law is being applied fairly and uniformly across the board. So it's the objective conduct that's at issue, not the subjective knowledge of the specific defendants.
It's not the subjective knowledge, it's the objective knowledge of the defendants here who saw this, recorded it, and made it a reason for them not being qualified to get out. They've documented it and used the documentation to disqualify them from being stepped down. What are you talking about? It's subjective. It's not just them. They have observed these harms and then found them. Let's call it insult to injury.
And I see, Your Honor, where that might bear potentially on the due process allegation. I don't see it in the context of Eighth Amendment conditions.
Okay, all right. I understand.
I see that my time has expired unless there
I took up almost all of your rebuttals, so I'm going to allow you to have 3 minutes to do what you would have done otherwise. I had not disturbed you.
I appreciate it, Your Honor. I will try to be succinct. On the due process, I think it's important to retain the lens that we're looking at post-segregation review. It's not the initial decision to put someone in segregation in the first instance, but hasn't been challenged in this case. The procedures that attend the decision to put them in segregation clearly comply with the Wilkinson dictates. When you look to the after the fact, ongoing post-segregation reviews, if you take the language in Hewitt, the footnote that says that, well, it's dicta in my estimation, although I understand it's been brought and incorporated into subsequent opinions from this court. They just say there has to be some sort of periodic review. And in Hewitt, if you read the entire footnote, the very last sentence of that footnote says, well, he was afforded one hearing 30 days after he went into segregation, so clearly it wasn't a pretext. That's the holding of Hewitt. When you look to Wilkinson, which was addressing putting the inmates in segregation in the first instance, but also looked at the entire procedure, there was one annual review that was upheld as being sufficient for purposes of due process. The Department of Corrections has gone far, way and above anything that was required in Wilkinson or Inkema or the other decisions that have been issued by this court. The policy, when you look at the policy, an objectively reasonable corrections official would not believe that it did not afford meaningful progression out of segregation. 511 inmates to 37. That fact speaks for itself. These defendants are entitled to qualified immunity. The district court should have granted the motion to dismiss the claims against them in their individual capacities and allow the official capacity claims to proceed as they are presently doing in the district court. Thank you.
Thank you. Thank you, counsel. Thank you all for your arguments. We can't come down and greet you, but no, nonetheless, we very much appreciate your helping us on this case. And we wish that you would be safe and stay well. Thank you, counsel.
Thank you, Judge.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
Would you like to take a brief recess or go to our third case?
Good morning, Chief Judge.
Yes.
Your Honours, may it please the court, Helen Parsons, petitioners in this matter. Initially, I would like to let the court know that we will not be arguing a couple of the arguments put forward by Mr. Matemu, who did the briefing. Section B1 of his brief on the issue of oral notice, I believe and agree with Mr. Anderson that there is no transcript typically as part of these proceedings, so we would abandon the oral notice argument as being without merit. Prior briefing counsel also addressed the merits of petitioner's claim. The Board of Immigration Appeals did not reach that as part of its decision in this case. So I don't believe that is proper. The merits of petitioner's asylum claim is properly before this court because it wasn't taken care of at the appeal to the BIA. There are two issues that I would like to focus on. The first is the issue that the court raised in its order just a few days ago concerning jurisdiction. And then I would like to briefly address the issue of tardiness versus failure to appear as time allows and as the questions allow. On jurisdiction, this court requested participants and the parties to address whether this court has jurisdiction to review an asylum-only proceedings. Again, initially, I would note that briefing counsel referred extensively to petitioners being in removal proceedings. Clearly, they were not. And I do not stand by any statements in the briefing that these folks were.
Okay, so since this wasn't an asylum-only proceeding, do we have jurisdiction to hear it?
Yes, Your Honor, and I refer you partly to footnote 1 on page 2 of respondent's brief and also to their 28J letter, which I will let opposing counsel raise. But every court, every circuit that has looked at this question of whether asylum-only proceedings allow for review by this court have answered that in the affirmative. Not always for quite the same reason, Your Honor, but within effect.
Even without a formal notice of removal order, correct?
Yes, in fact, I could not find another circuit where they addressed the fact that there had been a formal removal. There's no mention of a formal removal order. So in short, my position is, and I believe that the government is in agreement on this, is that the removal order issued in December of 2020 was actually surplusage to this particular question of jurisdiction. You know, the courts that looked at this have, you know, and I've got, we have the 2nd, the 3rd, the 7th, the 8th, the 9th, and the 11th. All of whom have determined that there is jurisdiction. And as I said, they've come to that conclusion, slightly different routes, but I think in effect, we're talking about the same thing. The 3rd Circuit in Shehu versus the Attorney General.
And so for what reason do you think that we should come to that conclusion?
I think the simplest is to adopt the language of the 2nd and the 9th and see this as the functional equivalent of a final order of removal. What if you go back and you look at what this does, it is the end of the road in a nutshell for this person. There is no further proceeding. At that point, they may be picked up and deported by, as the statute says, any immigration official and removed from the country. To see that as not being the functional equivalent of a final order of removal would deprive the individual, the non-citizen, of any avenue for review. And none of the circuit courts have found that that is appropriate. And I say they have found that it's either the 3rd and the 11th have actually considered it to be an actual order of removal, a denial of asylum-only proceedings. The 2nd and the 9th Circuit use the term functional equivalent, which I think is probably the most straightforward because it does what a final order of removal does. It makes somebody susceptible to imminent removal from the United States. The 7th Circuit says
Ms. Parsonage, it'd be fair to say that's just surplusage because they've already agreed to removal when they came in. So, you know, what difference does an order of removal have in this case?
I would say none whatsoever in terms of jurisdiction of this court to review this case. I agree, Judge Floyd. You know, the 7th said it was an implicit order. The 8th Circuit in Zine versus Mukasey didn't even question their jurisdiction, but they went ahead and reviewed an asylum-only proceeding. So I'm not sure they didn't make it jurisdictional, but I can find no court that has come to the opposite conclusion. So we don't even have a division amongst the sister circuits. This is a question of first impression here. But I think the fact that we're at the end of the road, I would ask this court to find this, basically the functional equivalent of a final order, and to find that, join the sister circuits in finding that you have jurisdiction over that, over this case. The second area that I want to touch on is the distinction, and this was raised by Mr. Matemu, the briefing attorney, whether there is a distinction between tardiness and absence in this case. And again, we have an issue of first impression for this court. This is not something that has been raised here before, but again, the sister circuits, the 2nd, 3rd, 5th, 7th, and 9th have all looked at this issue and determined that tardiness is not a failure to appear. I think the interesting case, you know, just if I can remind myself, excuse me, just 1 second.
Is it an exceptional circumstance?
Well, these cases from the other circuits hold that we don't even have to reach whether it's an exceptional circumstance, because under the plain language of the statute, which refers to a failure to appear, then if somebody appears, you know, the language says fails to appear or does not attend. Those are the two phrases in the relevant statute. And these courts have all held, and there's an enormous breadth to what is considered tardiness under the cases, everything from 15 minutes all the way up to the 7th and the 9th circuits that have found up to 2 hours. The common factors that these courts look at is whether the court was still in session. And I think that opposing counsel suggests that there's not really evidence in the record of that. I respectfully disagree. This hearing was set for 10 o'clock in the morning. That's AR page 89. Petitioners arrived at 11:05, and that's in page 65. So we have him arriving at 11:05. Court is, obviously this is still a morning session of court at 11 o'clock in the morning. So every case has looked at whether the court was still in session. We might be considering something different if court had finished, but maybe it was the end of the day, court was closed, but he didn't get there till after the session had finished. So the courts have looked at whether it's a short, and as I say, up to 2 hours in 2 circuits, half an hour.
So now he arrived at 11:05, you said?
According to the affidavit of co-counsel who was there to observe, and that's AR at page 65,
And where do we find that court was still in session?
I think because the court is still, hadn't gone on for the lunch recess, and the Fifth Circuit has said, even if the judge had, the judge isn't supposed to sit on the bench in an empty courtroom, but even if the judge had left but was still in the courtroom, and it's part of that morning session, then it is still during business hours. And I'd like to quote what they said. They said specifically, it doesn't matter whether the IJ was still on the bench or had left the courtroom. And to quote, a man's fate should not turn on whether he had the good fortune of other hearings being scheduled to begin subsequent to his own. In other words, the judge had to stay on the bench because there was somebody coming up imminently. So the fact that the judge may or may not have stepped away from the bench, I think is immaterial, because it was still during the business hours of the court. And it was an hour and 5 minutes based on the record. And that's well within the extremes that have been found by other courts. So I would ask the court to...
How did the negative assessments by the IJ and the BIA of your client's credibility factor here, if at all?
I'm not so sure that it does, the more one thinks about it, Your Honor. One of the circuits found the tardiness, I believe it was the Fifth Circuit, somebody had got taken a wrong turn and got lost. That was hardly a compelling reason for not having been there on time. He took the wrong exit off the highway. That's in Alison Chavez v. Gonzalez from the Fifth Circuit. He'd misfollowed his GPS, as many of us do. That would not rise to a compelling circumstance. Running behind because, your alarm didn't go off would probably fall into that same category. But, your sister circuits have found that tardiness is not a failure to appear. In fact, the respondents did contact the court and say they were on their way. So it's not like the bench didn't know that they were running late as well. It's not like they didn't provide notice. So I think, I would ask the court, as a matter of first impression, to find that there is a distinction between tardiness and a failure to appear completely, as is typically the norm procedurally in many other types of court.
And was this argument exhausted below?
I believe it was sufficiently raised, Your Honor. And as this court noted in Atem Keng v. Barr in 2020, there's no need for people to use magic words. And that's the quote from...
So what words were used below to sufficiently raise it?
Well, clearly in the motion to reopen to the immigration judge it was. But when we look at the motion to reopen appeal filed, counsel did ask the court to look at and compare and contrast his tardy but rapid appearance in Charlotte on the hearing day, standing in sharp contrast to an individual willfully failing to appear. So it was raised. Counsel did use in the brief the phrase tardy. The Board of Immigration Appeals did not address the tardiness issue at all. It may well be appropriate to remand to the board to make that decision, particularly in light of the fact that in June of last year, the board issued a published decision, matter of SLH and LBL 28 INN decision 218, holding that the extent of tardiness is a factor that should be taken into account. And obviously in this case, there was no discussion of the tardiness of my client. And I see that brings me perfectly to the end of my time. If there are no further questions, I would hand over to opposing counsel.
Thank you, Ms. Parsonage.
Thank you.
Mr. Anderson?
Good morning, Your Honor. May it please the court, Eric Anderson, Attorney General. Petitioners did not appear at their hearing in March of 2018, and their asylum application was denied as abandoned. We know they were not in custody at the time. We know that they had notice of the hearing date. The Board of Immigration Appeals and the immigration judge did not abuse their discretion in concluding that they failed to establish exceptional circumstances, and the petition for review should be denied. Like my colleague, I'll also address jurisdiction that the court had flagged in its order. Just the key sequence here is petitioners were admitted under the visa waiver program. They were referred to an immigration judge for their asylum application. All of the asylum application was conducted. They filed their petition in this court, and then CIS issued the VWP removal order against them. With that in mind, I would say the government stands by two aspects of its pending motion to supplement the record. One, the court has authority to take notice of these orders. Two, doing so would not violate the provision in 8 U.S.C. 1252 saying review is based on the administrative record. But to the extent we, I, at the time, thought the reason for filing this motion was you needed to see these orders to establish your jurisdiction. That is not the position of the Attorney General. On consideration after the fact, it is the Attorney General's position that the referral to the immigration judge would not have occurred unless DHS had already concluded that petitioners were removable under the VWP program. And given that there's certainty of the certain outcome, the fact that only the papers had to be completed, the completion of the order is reviewable. I'm sorry, the completion of the asylum only proceedings is reviewable in this court. I don't know if this court has any other particular questions about jurisdiction. I would say most of the cases are ones in which CIS issues the VWP order earlier in the process. The only one I've become aware of is the Machon decision.
I guess I just want to clarify that the government agrees that in asylum-only proceedings, we have jurisdiction to review those because, as opposing counsel said, there's nothing further to be done in asylum-only proceedings. It's the end of the road, so it's not necessary to have that final order of removal because it's effectively already been done. Is that right?
There's only one thing to happen at that point, the actual removal, Your Honor. So having addressed that,
Mr. Anderson, you all seem to disagree on the standard of review. Where did you get this facially bona fide standard you're pushing on the court? I mean, wouldn't we be better served to stick with our de novo and substantial evidence test?
Your Honor, the standard of review for a motion to reopen is abuse of discretion. I'm not sure where this facially legitimate standard is coming from. In my brief, we argue abuse of discretion review.
Oh, that's good. Oh.
I mean, I do know, I mean, generally, Kleindienst versus Mandel is talking about when you're reviewing a consular officer's decision overseas, how that affects the constitutional rights of a U.S. citizen who wants a non-citizen to be admitted to the United States. This is reviewed for, does the consular officer offer a facially legitimate reason? It's a very low-level review. I don't believe I cited it in my brief. I believe it's abuse of discretion.
I think that was my error. I was thinking about the Guzman case and not this one, so there's no problem about the standard of review.
Okay. Thank you, Your Honor. So what we know then is that petitioners were served notice of their hearing on March 26, 2018. We know from their own motion after the fact, their attorney received this notice. He mailed them this notice. In fact, his staff tried calling petitioners on the Friday before the Monday morning hearing and left a voicemail to remind them of the need to appear at their hearing on Monday morning. Nevertheless, they did not appear. They offered, because they were in telephone contact with their lawyer at the time, they offered the excuse, I have a flat tire. Now, an immigration judge is entitled to consider such an account may not be truthful. And in this case, we know this was not truthful because petitioner's explanation after the fact is, I didn't have a flat tire. They then offered the attempt to justify it based on lead petitioner's memory problems associated with alleged medical issues. But they failed to establish either the existence or the severity of these conditions. The only evidence they submitted to support it was notes talking to a doctor 2 months after their hearing, which did not include any diagnosis or any statement of the severity of the incapacity or how it would affect their ability to appear at a hearing on time. So I believe based on credibility and mere assessment of the record, the board did not abuse its discretion. They did not establish exceptional circumstances. To turn to the issue of whether they had to establish exceptional circumstances at all, our first response to that is no, this was not exhausted. A claim that I showed exceptional circumstances, which is what their brief to the board argued, is not a claim you should reopen and I do not have to show exceptional circumstances. These are different claims. Admittedly, the board has considered issues of how late were you in assessing were these circumstances exceptional? But that's different from the argument being pressed here that the board should reopen without requiring a showing of exceptional circumstances. Even apart from the lack of exhaustion, I would note that this was not, well, I would note that the record is devoid of evidence of what happened on this morning in particular. Yes, the hearing was scheduled for 10 a.m. Yes, the affidavit says they showed up at 11:05. There is no indication of anything else apart from this. To the fact that it was a morning hearing, this was not a mass hearing where you had an immigration judge with 30 cases before him that he was going to go through one after the other until he updated perhaps rescheduling cases, etc. This was their merits hearing. It was set aside as several hours on the schedule of the immigration judge. There is no requirement that an immigration judge on the bench with a petitioner who's failing to appear, an immigration judge who lacks foresight of the future, there is no requirement that he sit around and wait until they show up. So my first response to this argument is, of course, the lack of exhaustion, but I don't believe there's any basis for finding to apply such a rule here. So I believe I've addressed, the government absolutely believes there is jurisdiction. This court can review the asylum only. The board did not abuse its discretion in finding a lack of exceptional circumstances.
Well, Mr. Anderson, do you believe that there is a distinction, as your colleague argues, that between failure to appear and tardiness?
Failure to appear and tardiness, is that what you said, Your Honor?
Yes. Is there a difference between those two?
No, Your Honor, I don't. I mean, I do believe the board does consider how late were you in determining whether we should reopen, but you did fail to appear. The hearing said you had to be there at 10 a.m., the hearing notice, I should say. When you are not, you have failed to appear. And again, the immigration judge lacks foresight to know, is this person going to come down the hall 5 minutes from now, or are they just a fugitive, as it were?
So you would argue then that if you had a hearing and opposing counsel, and you didn't, and counsel and the client didn't come, or the lawyer, and the other side started their arguments, and they were 15 minutes into it, but the lawyer and the client showed up while it was in progress, that would be failure to appear.
Well, if the immigration judge hasn't, well, I mean, I guess I would tie it to, has the immigration judge issued his order yet? I mean, there's very little that DHS has to establish in such a case. It's simply the immigration judge calls the case, DHS says, we would like you to enter an in absentia order, and then it's done. So there's not a big window of.
So what time was that done? What time was that done?
Well, we don't know. He didn't put in any evidence to that effect.
Well, that would be evidence that you would have, wouldn't it? Wouldn't the government have that? Since it was done in absentia, how could he do it? I mean, don't you know?
Well, his lawyer was there. His lawyer who prepared the motion to reopen was standing in the courtroom. He had personal knowledge of everything that happened, and he could have put it all down in an affidavit, but the record is conspicuously devoid of any evidence apart from the hearing was scheduled for 10 a.m. He appeared at 11:05. There's nothing other than that.
Was there any evidence that he conveyed the excuse what you now say is false about a flat tire to the court?
Well, I say it's false because he said I lied about it, Your Honor.
Well, I'm giving you that. I'm giving you that. But is there any evidence that he made that false representation that morning and told the court that?
Through the attorney, but we don't know exactly what time this conversation between Mr. Solomeo, his attorney, and the immigration judge over the telephone occurred. What time that was relayed, I do not know.
It's more troubling in this case because you said they had set aside, I'm using your words, I think, 2 or 3 hours for just this hearing. You mean somebody tells you it's their last chance to determine whether or not to be deported. You already have 3 hours set for the hearing, and they tell you, or through counsel, they're on their way, they have a flat tire. And you mean someone says, oh, okay, this case is finished because you're not here now. That's what happened?
Well, Your Honor, the immigration judge is entitled to doubt the credibility of this, which we know in this case, he would have been absolutely on point to doubt the credibility of that claim.
Well, tell me the reason why he would doubt that claim at that time.
Well, because people lie to avoid removal.
Well, then I don't think anybody in the world who took a witness stand would have any credibility because people lie and they're persons, so they lie, so they're not credible. That's the most circuitous argument I've ever heard.
Well, Your Honor, the immigration judge, yes, has many pressing duties, and he had set aside this hearing this morning for Mr. Solomeo.
Was the immigration judge ever made aware of the petitioner's arrival at 11:05 or any time?
They do not make any claim to that effect, Your Honor. So I assume the answer is no, because they don't say they did, Your Honor.
All right, so you're just assuming that.
If they did make the immigration judge aware, it would have been sensible to say that, to record it, to put it in your pleading. Instead, we have a very skeletal factual record of what happened on that day. We have a subsequent claim of a medical issue that is not supported by any indication that Mr. Solomeo suffered from this medical condition on that day to such a degree it affected his ability to attend. We just don't have any evidence, and therefore the immigration judge and board did not abuse their discretion. And unless there's any other questions, we'd ask for the petition to be denied.
All right. Thank you, counsel. Ms. Parsons, you have some time reserved.
Thank you, Your Honors. Just to address a couple of points. We do have some additional indicia of what happened that morning in the affidavit from a staff member of trial counsel at the administrative record page 66, in which she details in great detail the back and forth phone calls. The affidavit that I already referred to on page 65 states that when Mr. Salameo arrived at 11:05, he was told that an order had already been entered. It is set out in immigration court procedure that once the order has been entered, you have to do a motion to reopen. That is indeed what they did. You know, on terms of whether it's abuse of discretion.
No, before you go there, counsel, it's something missing here in this. You mean tell me someone who represented him was in the court on time, right? Correct?
Correct.
And they allowed someone to enter an order finalizing their case in abstention and didn't walk up to the bench and say, wait a minute, my client is on his way, flat tire, overslept, whatever. They did nothing?
Well, apparently they did. At least that's what.
No, what about apparently you had an affidavit. Why didn't you say so?
There is an affidavit, and the trial attorney states this.
That's what I'm saying. But why did you go? Why did you jump to? It's already done. Why don't you tell us? Because that's the most important part. In real time, at 10 o'clock, what did they do and what did they tell? That's what we need to do.
We can't tell from the record exactly the timing, but it is clear from the record that trial counsel informed the judge that his client was on the way, for one reason, was tardy and was on his way.
That's what I thought.
And the judge, notwithstanding, entered the order. Because by the time petitioners arrived at the court, the order had already been entered. So we know it all happened within that hour. And as you mentioned, that hearing had been set to be a 2 to 3 hour hearing. So it was not unreasonable. And I think, I would just in closing ask the court to really look at the Nazarova v. Immigration and Naturalization Service case from the 7th Circuit, 171 Federal 3rd 478, that said that this is a 2-hour late case. Issuing an in absentia order in that case was a due process violation by the the IJ, the immigration judge, and therefore an abuse of discretion by the BIA because of her right, this particular person's right to be. So if it was not a failure to appear, it's a due process violation to issue an in absentia. If it's a due process violation to issue an in absentia, it is a per se, and several circuits, the 7th and the 9th have found that it's an abuse of discretion to deny the motion to reopen. There is a strong leaning in favor of allowing asylum applicants to present their case. This court, in an opinion written by Chief Judge Gregory, Atem Keng v. Barr in 2020, really stresses that the importance of that due process right to present your case. And that sort of adds an extra layer. This was an asylum claim. The merits are not before this court, but he had submitted, and you can see there in the administrative record, he had appeared at multiple hearings. He had submitted page after page after page of corroborating and personal documentation. This was a man who had an asylum case to present, whatever the merits. He clearly indicated that. Atem Keng v. Barr cites to the BIA's matter of Fifi and cites it at length for the proposition that there is a strong presumption that there is advantage to hearing asylum claims, and anything to do with the asylum, his credibility or the merits of his case should be addressed in an individualized hearing and not in some conclusory manner by a reviewing board like the BIA. And I see that I'm again out of my time. If there are no further questions, I thank you for listening.
Thank you, Council, both of you, for your arguments here today. We can't come down in our normal Fourth Circuit tradition and shake your hands, but no, nonetheless, we appreciate your arguments and being here today virtually. Thank you so much. We wish you to stay well and be safe. And
thank you, Your Honor.
Take care. Thank you. I'll ask the Deputy Clerk to recess the court until this afternoon.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.